Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is IMAX Theatre Services Limited versus Assistant Commissioner of Income Tax, pronounced by Delhi Tribunal on the 13th of May 2026. IMAX Theatre Services Limited, a Canadian tax resident, provided global maintenance services for IMAX theatre systems. In India, it performed troubleshooting, bug fixes, and software updates via remote access provided by Indian customers. An Australian vendor, Messrs ESPM, deployed its employee, Mr. Sunil Kumar, for on-site maintenance visits totaling 67 days in the relevant financial year. The assessment order under Section 143(3), read with Section 144(c)(13) of the Income Tax Act, 1961, and the directions of the Dispute Resolution Panel, DRP, alleged two categories of PE, fixed place PE under Article 5(1) of the DTAA, based on remote access to theatre systems, and service PE under Article 5(2)(l), on the ground that Mr. Sunil Kumar rendered services exceeding 90 days. The assessing officer attributed 25% profit, later reduced by the DRP to 12.5%, on revenues of Rs 61 crore, 85,848 from maintenance services and sale of glasses, invoking Rule 10 of the Income Tax Rules. The ITAT allowed the assessee's appeal, holding that no PE existed. The AO argued that remote access to theatre systems constituted a fixed place of business. The ITAT rejected this, applying the Supreme Court's ruling in Formula One World Championship Limited vs. CIT, 249 Taxman 192. Under Article 5(1), a fixed place PE requires the foreign enterprise to have a place of business at its disposal. The assessee's access was limited, customers granted temporary, restricted access solely for maintenance. The theatre system remained under the customer's control. The assessee could not modify hardware or exercise overriding control. The permanence test also failed. There was no fixed location, as access was intermittent and project-specific. The tribunal clarified that providing services from a remote location does not convert the customer's premises into the service provider's PE. Article 5(2)(l) of the DTAA triggers a service PE if services are furnished in India by an employee or other personnel for more than 90 days in any 12-month period. The revenue relied on Mr. Sunil Kumar's LinkedIn profile, claiming he was an IMAX employee. The ITAT found this evidence unreliable, as the assessee provided an affidavit from the Australian vendor, Messrs ESPM, confirming Mr. Sunil Kumar was their employee, not IMAX's. Even assuming he was the assessee's personnel, his presence was only 67 days below the threshold. The revenue implicitly argued that a virtual or digital PE existed through continuous remote monitoring. The ITAT followed the precedents in Clifford Chance and Ernst & Young Services Limited, holding that the India-Canada DTAA does not recognize a virtual PE. A fixed place requires physical premises at the disposal of the enterprise. Remote access, even if regular, does not satisfy this requirement. The tribunal emphasized that the DTAA must be interpreted strictly, and concepts like virtual PE cannot be read into it without express treaty language. Since no PE existed, the question of attributing profits under Rule 10 was moot. The tribunal did not examine the DRP's reduction of the profit rate from 25% to 12.5%, as the foundation for any attribution existence of a PE was absent. The ITAT's ruling reaffirms key principles. First, remote access to customer systems does not create a fixed place PE unless the foreign enterprise has disposal over premises. Second, the burden of proving a service PE rests on the revenue, Speculative arguments based on social media profiles cannot substitute for concrete evidence. Third, absent express treaty provisions, a virtual PE is not recognized under the India-Canada DTAA for multinational enterprises. This judgment provides clarity that temporary, restricted access for maintenance, coupled with short on-site visits under 90 days, will not automatically trigger PE exposure in India. Question: does remote access to a client's system always create a PE in India? Answer: The ITAT held that remote access does not constitute a place of business at disposal under Article 5(1) of the DTAA. The assessee's access was limited to troubleshooting and bug fixing, with no control over the premises. The Formula 1 ruling establishes that mere access is insufficient. The foreign enterprise must have unfettered use and overriding control. Question: what is the threshold for a service PE under the India-Canada DTAA? Answer: under Article 5(2)(l), services furnished by employees or other personnel in India for more than 90 days in any 12-month period trigger a service PE. In this case, the on-site presence was only 67 days, below the threshold. The revenue's attempt to aggregate other speculative activities was rejected. Question: is a LinkedIn profile sufficient evidence to establish an employment relationship? Answer: the ITAT ruled that a LinkedIn profile is not conclusive. The assessee provided a sworn affidavit from the actual employer, Messrs. ESPM, proving Mr. Sunil Kumar was not an employee of IMAX. Tribunals require reliable documentary evidence, not presumptions from social media. Question: can a virtual PE be invoked under the India-Canada DTAA? Answer: the ITAT, following Clifford Chance and Ernst & Young, EMEIA, held that the DTAA does not recognize a virtual or digital PE. The concept of a fixed-place PE requires a physical location at the enterprise's disposal, which was absent here. Question: what happens to the penalty proceedings under Section 270A after this ruling? Answer: since the ITAT held that no PE existed and no income was attributable to India, the basis for the penalty underreporting of income by misreporting collapses. The AO's penalty initiation was tied to the addition, which has been deleted. However, the tribunal did not separately adjudicate the penalty ground in this order. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.